Welcome to True Crime and Wine Time. I'm Teri.
And I'm Llama.
Tonight, we are uncorking the truth behind one of the darkest crimes and breaking it down together with you.
One case, one conversation, and one or maybe two glasses of wine to take the edge off. It's time to get comfortable and double check those locks before we get started.
So let's take a sip and dive in.
Hello, friends.
Hello.
Hello, hello, hello. Happy Monday.
It is, and it's not been a crazy technology Monday so far. Knock on wood.
For you.
Or for me. Oh, were you having it earlier? Okay.
Yeah, for some reason, my stream this morning over on CouchCore was like froze in the middle of it. I don't know what it was about. But we worked it through. It was just, we had to wait and be patient. So,
okay. I must have stopped watching by then.
Yeah, I don't know if it was before or after, but we worked it out.
Good.
Wouldn't be a Monday without tech problems.
That's right.
For one of us, anyway. Anywho, hello, everybody. Welcome in. We are here to talk more. Alex Murdaugh and his new trial that he was granted. We watched the appeals process last week, which was very interesting. He was granted a new trial. And so today we're going to be watching his first hearing of the new trial that happened on June 29th. So kind of new, but not. He does have an upcoming hearing next Friday, the 12th. So that's why we're trying to catch up to where things are now before we get too far behind.
It's true. We don't want to fall too far behind.
I know. I don't have to make slideshows and everything like I am for Karen. But they're helpful.
Hello, Dean.
Hello, Buffy. Hello,
And
Dean
Buffy.
Talks too. Hello. Good afternoon to you guys. Before we get started, make sure you hit the like button. If you haven't subscribed, hit the notification bell. If you're watching this as replay crew, leave us some comments and let us know what you think about today's show and the hearing, first and foremost. But yeah, what else do we have?
I think that's all that we've got going on today. I'm back with Dearest Mother's Darkest Secrets tonight at 9 p.m. Eastern, and I am covering Diane Downs.
Oh, goodness.
Yeah, and
Yikes.
I'm not a fan of hers.
You're not a fan of hers?
No. Not a fan. No, because some of the mothers that we cover have mental health issues, religious ideation, domestic violence. Then we have some that are just cruel and
That's
evil.
true. Diane Downs does fit that last
Diane's
category.
is cruel and evil, so.
Without a doubt.
Okay, Buffy and Dean, let's not get the flirts going in the chat today.
Get a room. No, just stay in
Get a
this room,
room.
please and thank you. Please and thank you. Well, excellent. Now, also regarding Murdaugh, we're also going to be covering his civil lawsuit against Becky Hill. Becky Hill was the reason he was granted a new trial in the first place. I can't recommend enough that if you aren't sure why he got a new trial, watch our last Murdaugh stream where we watched the appeals hearing. It is very educational. It is something that you don't get to see that often. It was with the Supreme Court of South Carolina. It was your first time seeing one of those, and you thoroughly enjoyed it.
I did. I loved it.
They're one of my favorite courts too. But I love how they do quick questions and all of that. So they ended up granting a retrial for Alex Murdaugh because of Becky Hill, the clerk of court, and her egregious misconduct with the jury members, with comments she made to them about, basically accusing him and his team of lying and all sorts of shenanigans she was up to. And she knew better. She damn well knew better. So we'll be getting more into that civil case because Alex has decided to sue her over it, which rightfully, I mean, good luck, Becky, because she did catch criminal charges on her behavior. So This is why it's important that nobody interferes in any sort,
Mhm.
excuse me, court proceeding, because it can have serious ramifications down the line. And Becky Hill definitely knew better as
She
a
knew
clerk
better.
of court. But that's why nobody should really get into we are on to you. Our little detectives over here. So we have the first hearing of this new trial. Like I said, it was June 29th, 2026. And let's see, we got closed caption on. This is brought to you by Live 5 News, the Low Country's news leader. Sorry, I just had to say it like that because I think it's hilarious. And let's see. I wonder where this is taking place because that does not look like the same courtroom as this previous one. But
Yeah,
all
I'm
right,
sure they have multiple ones. They may all look a little different.
that's true. This one's probably significantly smaller than
Yeah,
the trial one. All right. Well, you ready to give it a go then?
I'm ready.
Hi, Amos. All right, let's do it. Now, I also forgot to preface that we are a commentary channel. So if you don't like commentary, go over there on Live 5 News, watch it yourself. But that's kind of what we do here. So if you don't like it, that's fine. There's plenty other places you can find it. No need, uh, you know, to really say much about it, but just in case. Terry, is your mic using your camera? Or you mean, is the mic hooked up to the camera? Does she sound weird?
Do I sound weird?
I think you sound fine to me.
Say if I
Uh,
sound weird, I will unplug it and plug it back in.
no, I think you sound fine, but it could just be something on the other end. I don't know.
I mean, it's been YouTubing today or StreamYarding.
No, right? All right, let's do it. Commentary channel is just another name for shit talking channel. That's true. That is
Well,
true. Shit
we're not
talking and
really
snark.
chit talking. We're also educating.
That's true. All right, let's get into it, shall we?
Yeah.
I see we have a full house. Good morning.
Good morning.
For those of you who've never been to Lexington County, welcome
Oh,
to the Lexington County Courthouse.
Thank you. What kind of response was she expecting? We love it, Your Honor. It's amazing. Like she seemed a little like, oh. Sorry.
She's definitely Southern.
Definitely Southern, but nice. Nice.
She is
Okay.
nice.
So Lexington County, that is different. That is a different county than where he was tried. So it must have been moved over or something. I ain't
Savage.
educating nothing. Oh, here to shit
She
talk, like always.
she does Buffy look like Judge Bev. I had to do a double take.
Oh no. Oh no.
I would run.
She seems nicer already though. So
Okay.
Are you ready to call it? Can you call it? Give it right back to me. All right, we're here for a status conference.
Okay.
I'm gonna get the clerk to call the case, please.
In the matter of State of South Carolina versus Richard Alexander Murdaugh, indictment number 2022 GS 15-00592 through 595.
Thank you. All right, Mr. Waters, how are you?
Morning, Your Honor. Good to see you.
Good to see you. Now, let me ask you,
Now these
I
are
know some,
the same attorneys on both sides from the original trial. For those of you that are new, didn't watch the previous trials, same attorneys on both sides of the aisle here.
of your counsel at the table, but I don't know all of them. Can you
Oh, look,
please
we're gonna
just let
introduce
me
them.
know who the state's team is?
So I have David Fernandez, Assistant Deputy Attorney General David Fernandez. He's my number 2 in the state grand jury section. I have my boss, Mr. Don Zelenka.
I know.
We have John Metters as well.
I know Mr. Matters.
See, Your Honor.
So only Water, or the one that's talking right now, And the guy that he just interviewed Matters. Those were the only two that did anything for the state. Last time, not did anything. They had many people working on it. I don't mean to
But
say
they
the other people's
testified
work.
or got up and asked
They did a lot
questions.
of the questioning and all of that. Him and Matters were. And then on the other side, we have Jim and Poot, who did the same. But both have larger teams than that, just so we're all clear on that. But so these two guys here, I don't remember them from the first trial, so I'm going to assume that they weren't on it, or at least they never got up and said anything.
I mean, I
They see
kind of
it-
love that he goes, and this is my boss
Yeah.
right here. You know, that's
Well-
not intimidating at all.
Well, his boss was there for a lot in the first trial, but he wasn't trying it. He just like
Right, but he
sat
didn't
in the
sit at
pew
the
behind
table,
him.
right?
Right.
Yeah.
No, he did, but he sat right behind him like the whole time, mostly. So, and also, if you've never seen both sides' lawyers, they are very charismatic and entertaining, regardless how you feel about them. But I think they're both fun. The older guy did some in the first trial. What, the guy with the white hair? This guy here? Did he? I don't remember. I know this guy did. Matters. He's not a fan favorite. And Waters, but maybe he did. I don't know. Good question.
Various times, we have Assistant Attorney General Walt Whitmire, Senior Assistant Deputy Attorney General Melody Brown.
Right, welcome. Let me, Mr. Harpootlian, can you tell me, I think I know just about everybody at your table, maybe not everybody, but can you introduce the defense?
Please report, Your Honor. This is Jim Griffin,
Mr. Griffin,
Bill Barber.
Mr. Barber, good to have you. Okay. I've made some notes on a status conference, and I'll let y'all talk in just a little bit.
Oh,
But I want to go over what I want to go over.
wow. Okay. All right.
Like-
She's coming in hot. Like, it's my courtroom.
love
I'm running
it.
the show.
I want to talk about what I want to talk about.
Yeah. Right. Which I'll be honest, like you're kind of going to need with both of these parties to reel them in. Both sides are just, they will go off in a whole
Mhm.
different direction. And whatnot. So they do need a more direct judge. I thought Judge Newman was pretty direct, though. He was also a little like passive about things, but already I do love
Yeah,
that.
she.
So, oh yeah, he wasn't the one that was all up on the witnesses while they were. Yeah, no, that was definitely Matters. We did not matter like touching people. It was
Yeah.
weird. Not a fan.
Because I want to make sure that all the discovery in this case is complete. And I made some notes, and let me tell y'all, I don't know anything about the first trial, so when you tell me something, please be complete when you tell me, because don't assume that I know, because I don't. I want to know about phone records. Do we have all the phone records, and are they complete? Text messages, cell phone extractions, and if there's any supplemental extractions, video recordings, whether there's ballistic firearms, are we complete
I believe
in
you.
that? Fingerprints, toxicology. I think there was a blood splatter expert last time. I
Spatter.
just want to know where we are with these discovery items. I'll let the state address that, please.
Yes, ma'am, Your Honor. So we have provided, and obviously provided well in advance of the first trial, a very extensive discovery. I'm not aware of anything in the items that you mentioned that have not been provided to the defense. And if anything, the defense has more than the state does, because a very heavy privilege review was done, for example, on Murdaugh's phone, him formerly being an attorney and that sort of thing. So to my understanding, complete extractions were provided to them, whereas the prosecution team, the investigative team, only received the privilege review, some phone extractions as it relates to his phone and that sort of thing. As always, we are constantly auditing and looking at everything, but I'm not aware of any discovery from the very extensive productions that were made. not only from just the murder investigations, but also from the extensive state injury investigations as well. So we have provided those. And obviously, I'm not aware of anything in the categories that you mentioned that are not provided to you.
And not anything that needs to be reanalyzed or anything that the court would be waiting on?
At this time, no. Now, as you're aware, and we, of course, sent our responses to everyone last night to the defense motions that were filed late last week. Came in the office Sunday to write those. One of those is their request for independent testing on DNA. We put it in our motion, and I actually got an email from Mr. Griffin this morning that if they want to have their defense expert reach out to SLED as to specifically what capabilities they think they have and what they're proposed to do, happy to facilitate those conversations and discuss those with the defense and then with your honor if necessary. Right now, that's kind of where we stand on that. And of course, any other issues that arise along those lines, we're very reasonable and we're perfectly willing to discuss those with the defense. And if there's something that we can't agree on, obviously we'll raise those to you.
Okay.
So Waters has said a few things. One, they have no new discovery. They're using everything that they already had. There's nothing new for them to share with the defense. He does say the only thing that he doesn't quite have was that the defense had extracted a full extraction of Alex's phone, and they did give their stuff over to Waters, but it was not the full extraction because of privileged conversations. Because also, Murdaugh was a lawyer.
Right.
Plus, he had lawyers. So there's a lot in there that would have been protected for numerous reasons, I assume. But they have handed it over to the state. I don't think he was really complaining about it, just saying, hey, they did give us,
He's just letting
some
it
of
be
it.
known.
Right. Now, he says, we're not doing any new testing of anything. We're just going to play the same thing. But the defense is probably going to want to retest some stuff and we'll work it out. They will not work it out. Okay. I don't know this to be true, but I'm telling you right now, the state is going to do everything they can to stop them from doing anything new and extra, probably, and most likely, including DNA. They mentioned something about the other side wanting to retest DNA and things like that. So I wouldn't be surprised if they try to contest those. But right now, we're willing to work together, Your Honor. Everything is going fine. So that is their update for the judge. So let's see what's next. Also, I feel like if this was all hunky-dory, this wouldn't be an hour long, but here we are.
It would be shorter, right?
Yeah. I was surprised it was an hour, to be quite honest with you, but okay. Well,
Like
not
with
really.
Harpoon or
Not really, because I forgot Poot, as he's about to say. He's going to give us some history lesson first, and then he'll get into what he wants to talk.
But I'm here for it. I like Poot.
I do too. I like all the.
I mean, I don't like Poots, but I like Poot.
Mr. Griffin?
Your Honor, I want to address everything but the DNA.
Right, I'll talk about the DNA later.
So we don't know what we don't know. And I'll give you an example. And let me hand this up to Your Honor. I'll hand copies too.
We don't know what we don't know.
Your Honor, this is a transcript of an interview done with a guy named Chapman and another officer who were folks that arrived on the scene to begin with, to process the scene, and were very involved in the forensics of processing the scene. And if you go to page 6, Chapman, who's in charge of the scene, says this. This is a television interview on March 13th, 10 days after the verdict in this case. He says, in response to the question, I believe he had some help in the aftermath. Or Rutland, yes. Captain Chapman. You know, the disposal of weapons, the moving around a vehicle. We heard so much about SLED and AG's office, and they don't have anything. It's all circumstantial. So I pose this question to you. It was a clean crime scene, staged crime scene, clean crime scene. Would you expect to find more evidence or less? And that's what's kind of hard to get people to understand is we didn't find a lot. But why we didn't find a lot? Because it was clean. I mean, it was manipulated. There's evidence removed from the scene. Now, this is 10 days after the trial. This is.
I just want to say, all right, the investigation into these murders was not good. All right. The investigation was garbage. And it was very surprising how bad of a job SLED did at the time of this trial. It really, really was, because you were like, oh, these are two very wealthy people who were brutally murdered. How did you guys not handle this crime scene well? We thought, oh my God, SLED must be the worst state investigators. And then Massachusetts came in and said, hold my beer. I'm going to show you how we can do it worse. So I will say it is my personal opinion that SLED did a very not good job investigating right from the get-go. And they'll explain more at trial. But he's saying that this was said 10 days after the trial, that one of the people said, oh, it was a clean crime scene. It was staged somehow, which doesn't actually make any sense to me.
It doesn't make sense.
But I don't think that it was staged. I think that it wasn't adequately investigated or secured as it should have been. But it sounds like they're like, passing off some blame. Oh, it was all him. That's why it was so bad. Not us over here at SLED. Ugh, they left a lot to be desired over there. I'll tell you that. Okay.
Not what Chapman testified to. And if Chapman has evidence, there were other people at the scene that he had assistance under their theory, or there were other people there. We need to have that furnished to us. And
that's true.
We have other witnesses that testified at trial are saying something totally different, indicating there's evidence to believe that somebody else was at the scene, or there were other people at the scene. I mean, this guy's the chief guy in charge of the scene, along with Rutland, who processed it that night. We need, and we're in the process of doing this to determine if they did another statement or the reports. So we don't know what we don't know. We don't know what we don't have. We need some period of time to try to process that. And Your Honor, I say this, and no emphasis on trying to, we're not alleging that the state has hidden anything from us. We do know there were people that came to see us that said they had important information. We have no ability to investigate anything. We don't have subpoenas. We don't have grand jury. We don't have search warrants. And 2 or 3 of those people we sent to SLED. Did they follow up? One had extraordinary evidence about a tie-in between Paul's murder and the murder of a young man named Stephen Smith. But we had no, I can't compel anybody to come anywhere. We sent that to SLED. Did they investigate it? Have they investigated? And I must tell you, there are a lot of pieces of information out there that, and maybe they just stopped once they got the conviction, didn't do anything else, that it's inconsistent with our desire to get a conviction, have the conviction held. So they didn't follow it up. Maybe it does need to be followed up, but we're going to have to go back and look at all of that. We're going to have to determine whether or not additional material developed since the trial. And of course, all of us were shocked by the court report's conduct in the trial. I know we were, I know the state was.
We know.
So it's hard for us to go back and look at, and we haven't done a thorough check of all the testimony and read it all, not in the sense of an appeal, which we've done, but in the sense of, in criminal cases, we don't have depositions. We don't have them here. We have a transcript of but not every, I'm sure they're going to get rid of some of these witnesses who are horrible the first time around and get additional witnesses. But most of the witnesses, we have their transcript, their deposition. We need to go back and read all of that. And we need to get a sense of how you prosecute, especially in a civil case. So I can't say that we've got it all. I can't say that we don't have it all. Again, I don't know what I don't know, but I think
I'm a little confused, Pooh, what you're saying here. Okay, I get it. We don't know what we don't know, but also you have these people that apparently have all this new information. Don't you have your own defense team, like investigators as well? Like, why are you just sending them to SLED and being like, well, I don't know. I don't know what they did over at SLED. Like, I don't understand.
I thought that was weird because if they came to you, you don't need a subpoena. You don't need a search warrant. They came to you.
Right. Like, did you not interview them? Did you not have your own investigator look into it? Like, I know that can happen. Well, all right, maybe it's not like that in South Carolina. I wouldn't see why it isn't, but you know what? Different states do different things. But I mean, let's go back to, Karen Reed. Like her team investigated. They had their own investigation into things. They did not send everybody to the MSP or the Canton police. Like, come on,
'Cause
what are
you're
you
the
saying,
defense.
Toad?
Maybe you will. Yeah.
I don't know. He's not saying he's doing a poo and not saying a whole lot. Saying a whole lot about nothing. Of why the defense then, so they said they had these extra witnesses that have, things to say or whatever, and then they just sent them off to interview with SLED. And they don't even know if SLED checked it out or not, but they're bringing it up instead of, I don't know, investigating it themselves. Now, granted, the defense does not have to put on a defense in a criminal trial. They don't have to do shit. All right. They're not obligated to do shit, and you can't hold that against them. However, though, you are on a retrial and they did put on a defense the first time around, and they're going to have to do it again, in my opinion. So why are we just sending things to SLED, who we know is, quite frankly,
And I'm like,
ugh,
if they didn't do a great job, why would you send it to them? Why did you
Mm.
not get the information first? Because if they didn't investigate great the first time, what makes you think they've improved?
right, or
Just
that
my
they're
thought.
corrupt or whatever. Exactly. And Mary, I think, is on to the same thing, that they're trying to undermine SLED because they did do a shit job. But also, I wouldn't send then these people that are supposed to help exonerate your
Right.
client or whatever, just send them over there and not follow through and just be like, I don't know what they know. I told them to go here, and that's what I know. I'm like, come on, Pooch,
And
what are
why
you
would you do that?
right? Yeah, yeah. I mean, it was a shoddy investigation, but I don't think that's a good move on my. But what do I know? I'm just a girl with a microphone who likes to watch trials. All right, so back to what he was saying here.
we will be very diligent. And one of the other things we talked about is Alex Murdaugh's access to that information in a way that makes it convenient for him and doesn't inconvenience anybody else. We'll talk about that. That's another motion we'll talk about that.
I'll get to your motions in just a little bit. What I really want to know is about phone records, text messages, cell phones, video recordings, toxicology, fingerprints. You have all that discovery.
We're not sure, but we need to review it as if we were getting ready and it's brand new. I can't. Just because we looked at it 5 years ago, 4 years ago, doesn't mean we know we have it. We'll be diligent in doing that, but certainly I would think it'll take us some period of time to review that.
So you're saying you're not prepared to answer that question.
Right. One of the points, reminding me, we did not have OnStar data on Mr. Murdaugh's vehicle until halfway through the trial. That is not the Attorney General's fault. That is GMC's fault for not furnishing it. We had to do that on the run. We want to go back and analyze that, have an expert analyze that even more. I do on the other side, the Attorney General got it at the same time we got it. No inference to anything improperly.
Okay.
So part of what we need to do, we need to hire additional experts based on some of the views we now have on some of the witnesses, both the state and the defense have. And they need to examine those reports to determine whether we have a. So it's going to take a little bit of time, Judge. I can't tell you today we have everything because we don't know.
Okay. Let me ask you, Mr. Waters, what about the OnStar data? Do you have all of that?
Well, yes, ma'am. So, Your Honor, we actually SLED had sent 2 search warrants to GM well in advance of the trial, and we're told we ain't got nothing. And I think what happened was during the course of the trial, we actually had the FBI buy a Suburban and essentially reverse engineer the black box in the Suburban in order to provide us telemetry coverage. Of course, it's all provided to the defense. I think when that testimony came out during trial, somebody at GM was watching and they were like, uh-oh. And so in the middle of the trial, I get a phone call saying, about all that OnStar data, actually, we got a bunch of it. We immediately advised the judge, advised the defense, provided that to a usual form. They assessed it and agreed to go forward because each are curious about what has next. So that was nothing with the fault of the state, and we immediately engaged in what we needed to do to ensure the defense had access to all that information. As to him saying, we don't know what we don't know, well, I know my obligations are, and if I have knowledge of something that's disclosable, then it's been disclosed. And so to imply that there's something out there, I mean, we're always constantly auditing that and doing our obligations, but I take discovery obligations very, very seriously. Our knows that. As far as these musings, I haven't watched this TV interview. The musings of some captain about, whether the scene was clean. Well, there was evidence presented at trial that there was standing water on the concrete pad of the kennels, that the hose was not put back the way that it normally was coiled by the person who was in charge of taking care of those kennels. So he may have been talking about that, but ultimately, while Colleton responded initially, the scene actually was.
I don't think they're just talking about a water hose.
Yeah.
Water. Okay. Was it true? Yeah, but also that could be for numerous reasons. But yeah, the OnStar infotainment thing was a very big deal that came out of nowhere in the first trial, and I expect it to be a very big deal in the retrial here for sure, because it did come out of nowhere. I don't remember exactly why there were problems with GM, or there was something weird about it all. I don't remember what it was. I know the FBI was involved at the certain point, but I don't remember why they didn't get the infotainment stuff when they asked, but I'm sure we'll find out.
Do you think they're mentioning that they need to hire additional experts because they're out of money and they're seeking money to help pay for said experts?
They haven't said that yet, but I would think so.
That's
I
what
don't
I'm guessing
understand
there.
where all the money is coming from. Uh, but yeah, he does need to hire a lot of experts that they didn't hire this time around, especially if the state isn't going to change their position. They certainly need to hire additional experts to go through all of the forensic data. Will it make a difference? I don't know. But
We don't know what we don't
he is-
know.
we don't, which is so funny. I say that all the time. And now all I'm going to do is think of poo all the time. We don't know what we don't know, Your Honor. I don't know, but we don't know. But yeah, so I don't think they had experts on his side with the infotainment system. I don't think so either, because it was a very short window of time that they had between this came in. What will Whiffen say about Celebrate? That's a very good. He was a witness for the
Yeah.
state versus Karen Reed. His testimony was not great or helpful. And what he testified to in the Karen Reed trial about Celebrate and the different ways, it's actually just interpretive. It's not so much, direct how things work. And it was a lot of well, if it's this way, then that means it doesn't work, going back and forth
Right.
with him there. So I don't know. Is the state going to use him? Do you know, Lady Gray? Because I don't know the answer. I've heard that is he a state witness or Alec wins? Alec. Mm. Buffy says, I know a lot more about the court system now than I did when I first watched this trial. I wonder if I'd see it to a different lens this time around. Me too. I mean, I'm going in with an open mind to it. My viewpoints are known. I did not think the state did enough to convince me, but we shall see. And it seems like the Supreme Court had some questions regarding the state's case as well. So I'm not alone in that thought. But all right, let's see what else they have to say. This audio is garbage.
As I say, yeah, the background noise is awful.
Ugh.
Charged and processed by SLED, and they've had access to all that information. So to sit here and imply, we don't know what we don't know, well, I'll recognize that, but I know that my obligation is to provide that information to the defense, and if I'm aware of it, then it's been provided. And we have done that. They've had it since well before the original trial, and we will continue to do that. And as he freely recognizes, the OnStar data came in late despite our best efforts, and was immediately disclosed to them. They had every opportunity to process that information, and then they agreed, you know what, let's continue on. So that's not anything, any sort of indication of a bad process, practice on both sides.
So the bottom line is they have everything that you have.
To my knowledge, yes, ma'am, and we were very careful about going through all that discovery.
And you don't know of anything else that needs to be analyzed at this time.
Well, again, we have that DNA.
The DNA, and I'm going to get to DNA in just a moment.
Of course, it was analyzed ahead of time. Now, what we're talking about is some additional capability. And as I expressed in our motion, and Mr. Griffin has responded, I'm happy to facilitate discussions. And if there's some capability out there that's beyond the capability of SLED, and it has a reasonable chance of providing some sort of analysis, then we're happy to do that. Now, of course, if we put in our motion, ultimately, there's absolutely no evidence that Maggie Murdaugh was in a struggle with anyone, that she had any sort of defensive wounds, that she was scratched any sort of attacker. And we also know that it's very common how sensitive touch DNA is. We're constantly shedding DNA and picking up DNA from others by shaking hands and doorknobs and all the rest of it. So, this is a bit of a red herring, but that doesn't mean that we are not willing to discuss with the defense anything that they want to do, and if reasonable, we'll be the first to do that. And if then needs to come back to this court, we'll do that as well.
Okay, thank you. Sure.
We know from testimony in the first trial that the chief SLED officer involved admitted he misrepresented things to the grand jury. Since the trial, the case was dismissed, in which he testified because the judge found he was hiding evidence and misrepresenting that. That's the chief officer. No other.
Y'all remember that?
But it raised.
Y'all remember that trial moment when you found out that the head of the investigation lied in the grand jury?
Yep.
But again, the parallels to Murdaugh and Karen Reid are I understand they're very different circumstances, but this predated all of that shenanigans, but I was not being hyperbolic when I talked about how bad SLED in the investigation was for this whole thing. Listen, Alex Murdaugh is a shitbag and corrupt. Yeah. There is a lot of corruption all over the place. Okay?
In the low country, for sure.
Yikes. Oh, but I remember being like, right, yikes. Never good.
This is questions with us, not whether it's been withheld by the state, by the prosecution, but did he give them everything he had? Did he do what he did in the subsequent case after the trial where he had evidence? And I think we've got to go through it and look and say,
yeah, he hid evidence in another case, you guys.
Yeah. So what I find funny about all that, but yet you referred the people who came to you with potential evidence to get your guy off, but you sent them to the people who lied and maybe hid stuff?
I know. It doesn't make sense
for me, please.
It does not make any sense to me. I mean, I'm assuming that this guy isn't Whistlet anymore, one would think. But then again, look how long it took Michael Proctor to be and all of those fuck faces to be taken off of their jobs. So, you know, but it does make interesting. Are we sure? Are we sure that there is all this is? I think that's a fair question that Pooh is asking. But these all the lawyers are very long-winded. Okay, all of them. They will just talk and talk and talk, all of them. That I'm like, you could just say your thing and that's it. But no, we all need backstories. But I do think that's a fair
think
question.
that's fair.
Are we sure? Because we're relying on people that were willing to hide and or lie about things
Mhm.
regarding this case. So, and their investigation was shit.
Are there gaps here? Are we missing something? And for us, and look, we want to try this case as quickly as possible. No question about it. But what we don't want to do is not be prepared based on what we now know happened at the first trial. And we'll have a motion probably next week to expand on that a little bit. We didn't feel that we wanted such a motion to this.
Well, and I don't. You know, I really wanted to go over and see where we were with discovery. I want to set a timeline. I want to set out some pretrial conferences, and I want to set a trial date. That's why we're here today. And I want to go over some of these motions. I think some of them are not substantive, that I could go ahead and rule on those today and be done. And I will set up a pretrial. I'll give y'all some dates and hope you brought your calendars. And we'll set a pretrial. I don't know that one pretrial is going to do it for this case. We'll probably have several.
Yes.
And that's fine. The court's amenable to anything that y'all need. And happy to hear what you have. If you find something, Mr. Harpootlian, that you need to bring to the court's attention and you want to file a motion, I am more than happy to hear it. Okay?
It's efficient.
All right, so let me move on to my next notes. And we've kind of touched on it a little bit. Experts. Do you know how long? And the reason I'm just asking is because I do want to set a trial date. Believe it or not, overnight when I was assigned this case became the oldest case on my docket. And anybody who knows me knows that I will move an old case. And I intend to do that with this one.
Oh.
So I'm asking Mr. Waters, expert witnesses, do you know how long you need to get expert witnesses and talk to people and get everything that you need for the prosecution of this case?
Yes, ma'am. So the vast majority of our experts will be with SLED. And so I think that, you know, we are ready within reason, of course, to move this as expeditiously as possible. We do have another expert that testified from the FBI and things like that, but much of that is the same. And so as far as the state's position as to scheduling, and I know we've already sort of stated this publicly, that we were trying to do this before the end of the year, like towards the end of the year, we're ready to go. About that. And so I'm not aware on the state side of any expert issues that provide for additional delay.
All right, Mr. Harpootlian, how about for the defense?
John, we have 8 expert witnesses. All of them are new. All of them are just beginning to get the information they need. The DNA, when we are told, may take up to 6 months. It is, unlike what's been represented by the state, critical. And Mr. Griffin will address the specifics of that in just a moment. But to try this case this year, you know, you guys were talking about going to the death penalty 4 months ago or 3 months ago. Try it before the end of the year. It cannot be done for us to be adequately prepared. And we talked about the laptop. Without the laptop, we can't try it next year. If we have to go down there and take in the bank box at a time to read documents, almost 20,000 pages of documents. So we came up with a way to expedite.
Well, surely, Mr. Harpootlian, and he reviewed those before his first trial, did he not?
5 years ago. I mean, it's just a judge. I can't remember a case I tried 3 months ago when the materials on that. I mean, it's ridiculous to require him, not with all due respect, to require him to have a memory of each document that he looked at almost 5 years ago. And by the way, our solution to that, contrary to Mr. Waters' motion, is ironclad, no chance of it being distributed. We'll give them a laptop that's encrypted, that since there's no attorney-client on it, corrections can look at it, SLED can look at it, anybody can look at it, and let him look at that without us having to take hard copies of stuff down there and review it with him. Can't leave it with him under the court order. In other words, you just can't take him to discovery and leave it with the court order prohibiting that. And I'm sure the warden does not want boxes and boxes of stuff sitting in his. But if we have that, and he could be reviewing these documents and experts as we're reviewing them. I mean, let's not forget, he's a lawyer. Now, he's a disbarred lawyer, but he has probably more trial experience than many of the folks on either side of the court. So he understands.
I was wondering when you were gonna. You're muted.
Sorry, I was yelling at Zoe to come inside. She's busy licking a tree. I don't know why. It's just Zoe being Zoe. But first
Maybe
of
there's
all,
a squirrel in the tree, Mom.
no, it's like I don't know what she's doing. She's so weird. But so Alec was a civil attorney, which is not a criminal attorney. Those are very different kind. Now, do you learn all of that? Yes, you do. I'm not saying he's incapable of that. But so they want to give him a laptop so he can start going through all of these documents and have it while he's sitting in. I don't know if
With
he's at
them.
the jail or prison. He's probably at the jail now since it's a new trial. He probably got moved. I don't know that to be true, but probably. That's usually what they do. So they want to give him a laptop while he's in there to look over 20,000 plus documents.
And if they
Oh.
can't leave it with him, wouldn't it be more speedy if they could just leave it with him? What else has he got to do at night? He could read those documents then if no changes can be made to them.
That's what they say. But then they also bring up, there's Zoe. Okay, come on. They bring up, well, anybody can go through this laptop, right? It's the warden and blah, blah, blah.
Right.
This runs the risk of information, sensitive information being dispersed to the public. I think it's a little too risky, in my opinion. Many defendants are incarcerated, and they don't get those things. So I don't see why it should apply to Alec. He has a team. I mean, yes, you should be allowed to participate in your own trial, your own defense, of course, but I think we're pushing some envelopes here. Also, they seem to each think each one another is well, Waters definitely thinks everything Poot says is like disrespectful to him constantly.
Yeah.
It's like Poot didn't even say it that way, but sure, you're on the defensive, sir. But yeah, giving him a laptop, how is that really?
Well, if you think about it, if they
necessary?
take boxes and boxes of documents in, they could be gone through by somebody else. Are they letting Alex leave every day and go to the attorney's office to go
I don't
through those?
I
I
don't know.
wouldn't
That's
think
a good
so,
question.
because
No, usually not. Usually you're not allowed to do any of that, and it's very costly. Who was it? We were watching one trial where they did do something like that. Oh, which trial was it we watched last year? Was it Canero that got to view stuff on a computer at the courthouse or something? I can't remember which trial that was, but we definitely watched one where they allowed that, but it seemed like a hassle.
yeah, I saw one where they used like an iPad that was locked down. So it was in view mode only.
Which does sound like what Poot said this would basically be like, but I could see a lot of reasons why the
Yeah.
prison or jail would be like, nah, we don't got time for that. But all right, interesting. I think Lady Grace says, I think Sarah Boone had a laptop that she had to check out from the jailers, but she didn't get to keep it in her cell or at her bunk. Oh, did she? I don't remember. But probably. I mean, yeah, you are entitled to, help with your own defense, but we'll see.
What he's looking at, much better than any client I've ever had. So I think it's important if you're going to try to expedite this for him to have, and we can talk about the laptop separately, but that's going to be a condition. It's going to take us at least 6 months to get these folks retained, have them look at the adequate material, look at the state's testimony the first time around, and of course if they have a change in who they're using or taking a different approach, we need to know that as soon as possible. I would point out that they were giving us discovery in the last case after the first week of trial, in the second week of trial. So we can't have that happen again. If they say they've got it all, we're going to assume we have it all unless they want to supplement it. They supplement it sooner rather than later. That allows us to take it back. I mean, I think what we probably ought to try to do is figure out a trial date and then back up from that. And what we're comfortable with is late spring, early summer next year.
Okay.
We can live with that.
She literally asked you this from the beginning, when would be a good date? And you're like, you know what? I'm going to say all this stuff. And then be like, you know what, though? I think maybe we just should decide on this date.
And then
there's something. And I liked how I forgot to mention this the last time. He was like, well, I don't think we're going to be ready for trial this year. And it's like, yeah, we do know that. I don't think anybody's ready for a trial this year, Poot, but okay. Thank you for that. But no, he is right. They have, how many witnesses, or I'm sorry, experts did they give a number? I feel like they did, and I forgot what it was.
he said 8, that they were going to
8.
have 8.
Okay. So, I mean, you should expect at least 6 months for any experts, depending. I think that's a more than reasonable time if they've already started the process and contacting them and given them their stuff. Usually, yeah, it does take that long. So, okay. But now Pooh says, everybody, we got to pick the trial date first. Maybe that's where we should start, is with the trial date. But okay. Okay.
Given, I mean, if we have to go down there, one of us has to go down there 5 days a week, and we may be incarcerated on one mouse, and it's 2.5 hours. It's a half an hour to get in. So before they ever even see it, it's 3 hours. And then you only have 3 hours with them, and then it's a 3-hour trip back. That's why the laptop is so important.
Okay. Ms. Griffin, anything you'd like to add as to experts?
I have been in contact with the DNA lab in Houston. I can talk more about that. But when I mentioned that, they were asked, how soon do you need it? And I said, well, hopefully we're looking at a spring, early summer trial date. And the answer was, well, we need to put a rush on it. And I can talk more about the lab if Your Honor wants to hear it. I mean, they are.
I'll get to the DNA in just a minute.
DNA.
And then we'll go forward on that. All right. Let me talk about this computer at the Department of Corrections. I did receive your response, Mr. Waters, yesterday at 5. Did you get the opportunity to look at that, Mr. Harpelian? I mean, basically, I just made myself some notes. You were concerned about the state grand jury material and talked about a protective order and some other issues. I agree about there are some sensitive issues. The state grand jury material is protected and should be protected. And then you mentioned an order that Judge Newman
Yes.
had. I kind of think, Mr. Waters, that when this case was reversed, that order goes out the window and we might need a new order for this case. It's my understanding that the order stated that the grand jury material is secret. And I mean, that's pretty straightforward. And I know that you would like to prohibit the digital dissemination of the state grand jury material, that there's no photocopying, scanning. I breezed through this. You don't want any digital copies. And all of this, while it doesn't prohibit the defendant from reviewing the case materials, you want the attorneys to make sure that they keep in their possession the state grand jury material. Is there any objection to that, Mr. Harpootlian?
Well,
I'm sure.
Your Honor, the issue of that is what is the state grand jury material? I think, if we can designate what that is. It's beyond grand jury testimony, there's very little of that in the discovery. I think they've gotten things through grand jury subpoenas that have been produced, underlying records and whatnot. And so, is that really sensitive grand jury material? And some of us introducing evidence at the trial, I'm sure of that. But so no question about grand jury testimony. We have no issues with that. But it's just hard to say what exactly are grand jury materials when a lot of the subpoenaed documents and information have been produced.
and Your Honor, if the issue is dissemination, I mean, he has a right to read.
Oh, absolutely. I said that. It does not prohibit him from reading it.
The issue is dissemination. I mean, we're just basically talking about a big Kindle. You can read on it. You can't send emails. It's not connected digitally or cell or Wi-Fi to anybody. It can be connected. Let me say this, the Department of Corrections has been extraordinarily professional in dealing with us, giving us access to that. But no complaints with them whatsoever. But what we'd like that laptop with the warden and corrections to have total access to it. It can be inspected by SWED to make sure it can't transmit an image, a message, can't be used in any way. There is no Wi-Fi at this particular institution, so it has to be by self-service. And these are not difficult technical issues. And if they're concerned about grand jury testimony, we have to take that out. That's a 1% of what we want him to look at. And we can certainly do that separately with hard copies. We'd be happy to go down there and do that.
Well, let me tell you. Well, Mr. Waters, let me hear from you first.
Yes, ma'am. So we really, as far as the protective order, we really have two things. There was the state grand jury investigation, and ultimately there was the standard protective order for that. He's pled guilty to all those offenses. There's nothing to reproach about that. But necessarily, as that state grand jury investigation was going, things came up that were ultimately relevant to murder. So it was much bigger than they say. I don't have the number in front of me, Your Honor, but it was at least 20 witnesses, multiple subpoenas. And so all of this was in that ambit. And as well as Judge Newman issued a second, to my recollection, protective order as it related to just sort of the murder evidence as well. So they're two separate things, but they all blend together. And so all of this evidence is sensitive. On top of that, the murder evidence is in fact very, very sensitive. And frankly, we've been trying our best to protect it from improper dissemination because it's worth a lot of money. Now, one thing SCDC is adamantly opposed to, okay, is having an inmate have a laptop. They are absolutely 100% opposed to that. And I have to remind you that this is an individual who already had his tablet privileges taken away from misuse of that. This is an individual who was caught receiving contraband that was passed from a family member who proved the defense to him, found like guys. And so this is not a guy and this is also a guy who's been convicted of over a decade of fraud. Now, they say that these things can be locked down and I understand these issues very well. As the state grand jury made a point to partner with SCDC to fight the problem of fraud and corruption emanating from there, and it's done with the use of devices. This is a very severe security issue, and no matter what protections are put in place, there's always ways around those, and SCDC has experience with that. So the fact remains is he's an inmate. And SCDC adamantly opposed to there being some laptop that he has access to, including this idea that SLED is going to be able to review, attorney communications and work product on that. I don't understand how that's going to happen. Now, SCDC is happy to accommodate the defense and to any meetings they have. And no one says that the defense can't bring down digital evidence to review with them while it's under their supervision and then take it with them when they leave. That is absolutely the way it should be, that ultimately this information, whether state grand jury or not, it's too sensitive to have an inmate, despite what protections are put in place, have a laptop, because frankly, the reality is inmates are constantly and successfully violating whatever protections are put in place. Despite everyone's best efforts, you're doing a great job. It's just a measure.
Okay. Sure.
So they want him to have this because he's in prison. So they're talking about prison, not the county jail. And he's 2.5 hours away. And the lawyers are like, it's an all-day event to go see him once a week, which is true. I could also just have him be brought back to county, which I know Alec does not want to do because county sucks compared to everything he's allowed to do at prison. But I mean, that could just be the solution. Like, well, we can move your client closer then. I don't know.
I just had to go look up what he got caught with for contraband.
What's
It was a
that?
book. It was an unapproved book that his sister handed him. And there was nothing hidden inside the book.
Yeah.
I mean, but the way they said it, I was like, oh no, is he getting drugs in prison?
No. I mean, everybody gets written up for something in there. So there is that. But yeah, I don't know. I guess that would be a solution, but they're not wrong. Also, I just want to know that I don't understand why grand jury stuff's so secret. I hate it. I think it's stupid. Just putting that out there. Stupid. Everything else is transparent. Why can't that stuff be? But anywho, what was the book? Kelly wants to know.
I don't know. It doesn't say.
Oh.
I had a series of emails, and I don't see the Department of Corrections here today. I had an email chain with the warden at the particular institution, and he doesn't raise those objections. He just, and we were bringing another laptop, and we can't have cellular or Wi-Fi capabilities. So, and that's what this says. So, and with all due respect to the Department of Corrections, if you don't get the ability, I mean, if Mr. Griffin and I, or Mr. Barlow, or Ms. Fox have to go down there, 3 hours down, sit with them for 3 hours, 3 hours back, we're talking about at least the end of next year, if not the beginning of the following year, to get this support. We can't be working on experts, and we can't be interviewing witnesses while we're tied to sitting there and babysitting him while he's reading a laptop that doesn't have any capability to communicate or copy. And we'll be happy to have SLED inspect it. We'll be happy to have the Department of Corrections inspect it. But, the idea, we bring laptops in. We were given, as you can see, permission to bring laptops in. Laptops are brought in all the time. The question is, can he keep, not he, but can the warden keep it, or some office at the institution keep it and give it to him when he needs it? And Your Honor, I gotta say, the idea of bringing him in here chained up, the idea of not letting him have access to a laptop, the idea of opposing everything we're trying to do to expedite this process. I understand it's Mr. Warner's job to legally prejudice the defendant, but this is beyond the pale. This is beyond the pale. I'd ask you to remind Mr. Warner that he has an ethical duty to see that justice is done, not to get a conviction. Thank you.
You're so funny.
Wow.
Hey, why is he dressed in orange and handcuffed? This is unacceptable. What are you talking about? It's not the trap. This is how they all come in, no matter what. If you're incarcerated, this is how you come in. You come in chains for a reason. You're wearing the jumpsuit. None of that applies quite yet. He's like, and Mr. Waters just has it out for him, which don't get me wrong, he does.
Do we blame him?
But I don't think that there is that his client is being prejudiced
Mm-mm.
against right now for how he's dressed and in chains.
And he looks good in orange from the side profile.
But I will say Waters does. He was like immediately like up, like I'm ready to argue some more. Oh, they're also long-winded and back and forth. So they're all whiners. I think they're all whiners, Lady Gray. They are all whiners to me. And I feel like this judge is going to get very over it and be like, you all are grown-ass men. What the fuck? I would be. I did not forget. I did not forget. I think they're good lawyers. I enjoy them. But they can get very interesting and exaggerate things a lot. So.
I don't. And that,
Okay, we're not going to go there.
and I have no intent to prejudice anyone. Prejudice suggests a decision on an improper basis.
And the court doesn't take it that way, Mr. Waters.
Thank you, Your Honor.
All right, let me tell both of you. I took the liberty of calling the warden and talking to him about the laptop situation.
Oh.
And because I too used to practice law, I remember terabytes of discovery that I had to carry to my clients to go see. And I know that it can be cumbersome, and I would imagine the discovery in this case is a lot.
Gigabyte.
How many pages do we have, Mr. Waters?
It's very extensive. It's half a terabyte.
Half
Half
of
a
a terabyte.
terabyte.
Okay.
Which they said was about 20,000 pages, which that's a lot. But we have Karen Reed, where we learned there's over 1 million documents from one discovery. What was the other one that was just 4.5 terabytes of something that we've been
That's just crazy.
covering? What case was that? Oh, it's Laura's, right? Laura Owen's case. They said they had 4.5 terabytes to go through. That's a bunch.
That's a lot.
I'm surprised it's only half a terabyte, honestly.
I know. I'm like, why is it so small?
Yeah, it does surprise me that that's all the bigger it is, but okay. Interesting. BK had, she's 2 seconds of saying bless you. BK had 1 terabyte. Oh my gosh. Is that 20K of new documents? No, I think just overall.
For him to review them again because he couldn't possibly remember them from 4 years ago.
Right. Okay.
I talked to the warden. He will not allow a laptop. And for safety reasons, he said he would, quote, make available a conference room. Counsel may bring their computer. They could have a law clerk come, or the attorneys could come themselves. They could look at it. He could review his discovery. They could bring their own laptop. However, somebody must be with him. His concern was having a laptop in his cell. And no other inmate has a laptop in their cell. They do have access to an iPad that has Westlaw on it. Now, I just have to be honest with you. I didn't even think about asking him if you could download any discovery on that iPad. I don't know if that's available, but I certainly will call and check and see if that's acceptable to him.
There's a lot of things they can do with it.
If that's the case, I'm going to have Mr. Waters draw me up a proposed order on the state grand jury material. I haven't looked at Judge Newman's yet, but I will. Please run that proposed order by Mr. Harpoolian and Mr. Griffin. I will check on the downloading on an iPad, but I'm not going to allow him to have a laptop computer in his cell. It's for safety reasons. That's out of my control. I think it's not only for the safety of the others at the institution, but probably, Mr. Murdaugh, for your own safety.
Mm.
Okay?
We talked to the warden. We're not proposing he have it in his cell. We're proposing that the warden have it and give it to him to go to a conference room as he would with us to look at it there. Does that make a difference?
Well, I'll ask him. When I read your email here, this seems like he could go to his cell. He could keep it in his cell. I know good and well that the
Says
warden
that.
is not going to allow that. I talked to him personally.
I have an objection.
Okay. We'll follow up on that in our next pretrial. Or if I can, I'll probably let you know before pretrial, but if he says no and it's for security reasons, then the answer is no. I'm not gonna allow it. Do you understand? Mr. Harpelian?
But
Mr. Waters?
Law clerk or other person, paralegal?
He'd let a paralegal go. All he wants is the name of the person, and you're more than happy. And he said he's not gonna limit you to 3 hours. They can stay 8 hours if they want. He will make a conference room available so he could see the material.
Llama, you
It
should
does
go help.
not have to be a lawyer.
Oh, it doesn't have to be a lawyer.
Okay, that,
Your Honor, I spoke with the director of Federal Counsel this morning, and they expressed the same thing. We're here to facilitate the defense doing that.
Right. I want him to have all his discovery. He's entitled to all of it. It's safety concerns. It's,
Your Honor, 100%.
if you can have a law clerk or a paralegal go down, then you're satisfied. Mr. Harpelian, that'll help you out.
It will dramatically, we're not limited to 3 hours. It makes that 2.5 hour trip down and 2.5 hour back worthwhile.
Okay. Well, then I will verify that and send y'all an email tomorrow on that. That's okay. All right, perfect.
Thank you, Your Honor.
Well, thank goodness we had a
All
whole 20-minute conversation about this when she already called the warden. Thank goodness, that's all. Oh my God. Okay. Oh, I forgot so much.
Now, let me go through. I had a motion filed for the defense, and I just want to put this on the record. The defense wanted the defendant to be unshackled in the courtroom. I received a response from the state. They objected. Then I had a response from Mr. Harpelian where he withdrew that motion. That still stands, Mr. Harpelian?
Interesting.
Yes, Your Honor, although we may renew the motion, the reason for this is potential jurors are watching this right now. It's going to be, wherever this goes, it's going to be difficult to get a jury. And to the extent that parading him around in a jumpsuit shackled like an animal impacts their view, it's going to make it more difficult for us to get a jury. Now, again, Mr. Waters' argument is specious. He's not dangerous. The only thing he can be convicted of is stealing money.
That's
Now,
not true,
Judge
though.
Newman let him come to the courtroom in street clothes and unshackled. I know Mr. Waters feels compelled to get every advantage he can, but this is one that prejudices our ability to get a jury. So I would ask that he be allowed to come in the courtroom unshackled in, I will call them street clothes.
So
Now,
are you renewing your motion now?
sure,
Sure.
Just want to make sure.
Sure.
I want you to see today.
Oh my goodness. Oh, his demonstrations.
I mean,
Oh, here we go.
chained around the waist, chained to the hands, chained on the feet. I mean, this guy is not a serial killer. He's not,
He's not a serial killer, excuse me?
She could sit down, Miss Murdaugh.
And how was he convicted? He's accused of killing his wife and son. But he was accused of killing his wife and son, and Judge Newman allowed him to come unshackled in his street clothes every hearing we had.
Well, the reason why that was allowed is because he actually wasn't guilty of anything at the time,
Right.
including the financial crimes, because he did not plead guilty until a whole year after the murder trial. So that's one
Mhm.
reason. He had no prior convictions. Now he does.
Mhm.
But also, every defense attorney makes this argument for their client if they are, you know, in clothes and handcuffs. Every single one makes this argument, but it's flair for the dramatic. Look, Your Honor, he has a belt and handcuffs are all over his body.
Because the
All
judge
of
has
it.
never seen a prisoner before, right?
Right. Oh goodness, I missed them in their dramatics. But I mean, and he's like, well, future juror could be watching. First of all, they're probably not going to make that jury if they're watching right
Yeah.
now. I think more so than news, perhaps, they would see that. But I mean, she'll probably end up granting it, but whether or not it needs to be right now, I don't think there's a problem with that. For most defendants, it is true. It does create a prejudice ahead of time. I just wanted to point some of the differences, though, between the first trial they want to keep bringing up and this one, right? Because the judge has a few more things to take into consideration. Because he's like, the only thing he's guilty of is financial crimes. And it's like, yeah, but he's also like in there for double murder right now. So
Mhm.
I know you got a new trial. So technically that's been vacated. Technically, he's not guilty of any of that, right? He's innocent until proven guilty
It's
again.
starting over.
Right. But he is still technically a felon for all of the financial crimes. Because even if he gets this new trial, y'all, he is not walking out of any prison.
Mm-mm.
I forget how many years. Didn't he get like 15 for the financial crime? 15 or more, I think it was. So it's not like he's going to be walking out free at all. He'll probably go to a federal prison at that point, which is apparently a lot better. But oh, stand up, Alex. Stand up and show them. Oh, they're so funny. They're so funny. But again, every trial I've watched, defense has the same argument, and they're not wrong. There is science that backs that up. But
Mhm.
All right, Mr. Waters, I did read your response, but I'll be happy to hear anything and I'll take it under advisement.
Well, again, they withdrawn the motion and now they.
Now they,
This goes back to, it's not the state's fault. He's an inmate serving a 27-year sentence, okay?
27.
This is, again, SCDC's policy for non-jury court to have to be dressed out in restraints. He's not only facing 27 years, but an additional 40 years in federal court, and he's also indicted for a double murder. So this is a basic security consideration. Again, the intent is not to prejudice anyone. The intent is the security of every time someone is transported out of court. It is a security risk. And the first two goals in any escape attempt is to become unrestrained and in civilian clothes. So I'm here to represent what is basic policy and procedure for inmates serving long felonious sentences with SCDC. I completely understand that we have a jury, the calculations are different, and that is going to be a different thing to do. But the remedy for all of that ultimately is our process. It's going to be jury selection, and it's going to be instruction from the court, which the juror is going to follow, and I know our citizens can.
okay, thank you. All right, I'll take it under advisement and I'll issue an order on that.
Okay.
Let me move on to the DNA. Again, I just received the state's response yesterday at 5 p.m. I read it, and I'm going to save it for the next pre-trial because this is what I want to know. I'd like to know how long, Mr. Griffin, it's going to take to analyze exactly what it is you're asking for. And I believe it's genetic.
Yes, Your Honor. And the state's response says, give us somebody to talk to at the lab.
Okay.
So
And
that was conveyed to them this morning. The CEO of Othram's name, email, and telephone number. They have received the VP of Law Enforcement Division at Othram, his cell phone number, and the client intake person that we use. Now, that that I've been interfacing with, and they will be better able to answer specifically how long it will take. We've agreed to pay for it, and just background information.
I'm gonna let you pay for it.
Yeah. And these murders happened in 2021. We're in 2026. 2021, there's no such thing as artificial intelligence. In 2021,
Do we know
this
these?
genetic genealogy was just on the ground floor. In 2026, we are light years ahead. And so what we're asking for didn't really exist in 2021. It does exist today, and Othram is the leading lab that performs this analysis. They did last year in 2024, the statistics are that they cleared 200 cold cases on behalf of law enforcement around the United States and the country. They work with law enforcement every day. The most high-profile case they did was at the University of Idaho.
No.
The Moscow, Idaho murders that took place about the first week of our trial. College kids were massacred in a house at the University of Idaho.
It was like several months before your trial, but sure. Your trial was in January. Theirs happened November 11th, I believe. So not the week of, sir. Also 2 different years, but okay. Not quite. Did they also use this, Buff? Did they use this with Lisk? Is this one of the companies they were arguing with before he went and did his guilty plea? Because if so, then I recognize the company that they're talking about. So
They had a DNA sample they ran through CODIS. Came up nothing. There was nothing. The state of Idaho Police Department, like SLED, had a contract with Othram. They sent the test Othram. Othram does this genetic genealogy DNA analysis, and it comes back to a family member who'd done a DNA test, ancestry test, of the person who committed these murders, Brian Koberg. That's how they solved the Moscow murder cases, was through Othram lab. The difference between, and they say they don't have enough samples to get through CODIS, and I've talked to the lab about that, and that's not an issue. CODIS uses analysis called STR. This analysis is SNP, and they call it SNPs. CODIS has 20 data points. SNPs has 500,000 data points that they analyze. Now, it takes a while to do that. And so, we're going to have to see what the lab says. They've asked me to get information from SLED as to, they'd like to see the electropherogram or mixture proportions so they can have a better handle on it. And I'd ask Mr. Waters to give us a name so that these experts can interface. But what they're doing in Houston, Texas, they don't do in South Carolina at the SLED lab. There are handfuls of labs around the country, and they are, they're certified. They work with law enforcement. I don't know that they work specifically with SLED. They're familiar with SLED when I spoke with them, but they have a whole division.
So you need an expert's name or whoever has this sample to see if there's a viable sample that you can send.
Correct. And they can work with the extract that SLED used when they did their STR analysis. They can work with that out there. They told me, but
Mr. Waters, can you give him a name so he can move forward?
That's what I put in my motion, Your Honor, is please give us a name, and I'm happy to have SLED reach out and talk to them about what their supposed capability proposals are and any procedures. And I'm then, once made privy to that information, I'm happy to discuss those with the defense. If for whatever reason we can't agree, we'll come back and figure it out. That's precisely what I put in my motion is let's talk to them, let the experts talk so that my experts can hear, what it is that they propose to do. And I'm happy to do so.
So that's very Waters. You're going to hear this nonstop for months I'm always happy to. I'm happy. He's never happy. He's never happy to cooperate ever. And then of course, from the other side, you're just going to hear, well, we don't know what we don't know. So just prepare yourselves. put those on your bingo cards for when it gets to be trial time, because you're going to hear a lot of those. So again, thank you, Bell Stitches Pirates, for the jewels and sending us a clutch. Thank you. So kind of you. Hello, Helville. Good morning, afternoon. Afternoon, babes. Hope you're doing well today. Okay. So they're very happy to work things out. I'm going to look more into this awesome list because I'm very skeptical, just as some of the others are, about all of these, but okay.
And I gave him 3 names and contact information this morning, and I've asked a name that I can send back to my folks. I do want to address this red herring argument. The DNA that we're talking about, Your Honor, came from Maggie Murdaugh's left fingernails. That was tested by SLED with this STR analysis. The DNA sample number 70 that we're asking to be tested, it positively was not Alex Murdaugh's. Any of the other folks who they took buccal swabs from went through a long list, not them, except for one potential. And that potential, the ultimate result was it's 11 times more an unknown male, so they know it's a male, than it was this person. That's how they do things in their DNA analysis. And Mr. Waters said, well, there's no evidence of struggle, but there was a shell casing under Maggie Murdaugh's body from the gun that killed her. I mean, that shell casing and that gun had to be in very close proximity. Maggie Murdaugh's cell phone was missing from the crime scene. Was DNA transferred at that point in time? And so we don't think it's a red herring. We think it's very important. Now, it may turn out to be, innocuous. We don't know, but
we don't know what we don't know.
Looking into.
Okay, I haven't said no. This is what I do want you to do, though, Mr. Griffin. I want to know how long it's going to take to analyze what it is that you're asking for. And even if I expedite it, I'd like to know how long it's going to take.
For now.
And I'd also like to know if there's even a viable sample that they can get. And we will discuss this at our next pretrial.
Oh.
Anything, Mr. Waters, you're going to give them the name of the person at SLED that he can get in contact with. Let's see if there's a viable sample.
And the lab has told me if there's not a viable sample, we'll tell you that. But
right.
they work with a lot less than
okay.
SLED.
Well, let's start with that. Let's make sure we get a viable sample, and then we'll go forward, and we're going to go forward at the next pretrial. I promise you, the pretrial is not going to be that far away.
Next week.
All right. Let me move on to the motion for change of venue. The defense filed a change of venue motion. The state has not had the opportunity to answer yet. So I'm going to give them time. In the meantime, before our next pretrial, if at all possible, if y'all agree on a change of venue, please give me some suggestions if y'all can agree on it. If you can't, make your own suggestions, and then I will decide for you.
It's absolutely going to be
if
moved.
we go that route.
It's got to be moved, I would think.
Even in spite of the acrimony here today, Mr. Lord and they were able to talk to each other, and we have already talked about this. I think we'll have continuing discussions. And depending on when you set your
An answer for me?
They're talking.
I don't have to keep driving down.
Yes, Your Honor, of course, and without taking a specific position right now, I
Right.
Mr. Arpulin this morning that, we can kick some things around, and like you just said, if we agree, great. If we don't, then of course we'll decide.
That's right. Don't have a problem with that. Okay, perfect. All right, now let me address, I see Mr. McCullough sitting out there, and then
I think that they have no choice but to move it because not only is it a very small town, small area,
Mhm.
the fact that it was a staff member
Who-
from that courthouse that has caused this whole retrial, uh, I don't think that there really is a choice. If we
Yeah.
want a fair trial here, I know
Agreed.
I wouldn't want to risk another, anyone's comments about Becky. Anything could happen over there, and that sucks that one person kind of made it difficult. But again, this is why these things are important. So I imagine that they're probably going to do a venue change.
I would be shocked if they didn't.
I would be too, considering why there's a whole new
Mhm.
trial, because that was the only thing granted on appeal. When is the next pretrial hearing? Next Friday. So we will be covering that next Friday afternoon, where apparently they're going to be talking about DNA.
Mhm.
They're going to be talking about change of venue. So who knows what else they're going to be talking about. But man, I forgot these guys can't talk into a microphone to save their lives. At least they're standing still, which is much
Yes.
better than in the trial where they were just all over the
Walking
room.
around everywhere.
Goodness. All right, almost through it, friends.
also have another, they're both
DNA.
the same protective order, but they're wanting two different things.
Ours is not the same as Mr.
That's right, they're two different things.
Barber will address on it.
Right. As far as, but I think before we go there, Mr. Harpootlian, I believe, Mr. Waters, am I correct in stating that you're working on a response to both of these? There might be some redactions that you wanted, and you're going to submit that to the court? Okay, and I'll be able to address that at the next pretrial conference.
Again, we are generally in favor of those being unsealed, but they will have to be done judiciously and with appropriate redactions to preserve their identities and actions.
Right, because I did, yeah, and I did receive something from SLED, an email from SLED.
That was General Counsel Adam Whitson, who's present here today, and Sledge.
Where is he? Okay, I did receive your email. Just get me an answer on that and we'll decide at the next pretrial then. Okay. Those were all my bullet points. So let me ask the lawyers, did I miss something? Is there something you would like to add?
One thing Your Honor had mentioned is the location of pretrial hearings. And from the state's perspective, we're happy to come wherever Your Honor happens to be and for the proceedings.
Okay.
And we're more than happy to come wherever you are, although this production of these hearings might not dictate, but certainly suggest we come to a venue like Washington County, where there's plenty of room and have an extraordinary accommodating everybody.
I think they've done a really good job with security and with the press and being organized. And this is my home county. Let me just ask and throw this out there.
Right.
Mr. Waters, is there any,
They are so ridiculous. By the way, Your Honor, I'm just saying, I know we're supposed to wait and talk, but can I tell you how much I like this place? Can I just tell you how great this is? Just put that out there and just saying is all. He always, well, they all do. They just try to get in with
I
little
do.
things here and there. Oh, thank you, Mary, for sending happy
Little
food.
brown nosing going on.
Yeah, they play it like little seeds. They all do it. They all do it. It's not just Poot specific, but oh man. All right, let's see what Waters has to say about this. What?
objection if we hold pretrial here? The reason being, we have a big courtroom. I already have security set in place. I think the clerks and both clerks and security have done a really good job. This is not the only courtroom in this courthouse, so I won't disrupt holding court in Lexington, which I would not want to do to any county. Sometimes I go to really small counties and I don't think it would be good to hold a pretrial there. Does it suit?
I mean, from the state's perspective, and again, being a longtime AG, I've been in pretty much all of them. And as an AG, Lexington is like a second home, obviously.
Convenient.
Solicitors, obviously, law enforcement, the court, of course, is very accommodating here. So this is certainly, I think, would be of most convenience for parties as we get ready for the trials.
Okay, it's not far for anybody to travel, Mr. Harpootlian? Okay, and I will try to make sure that when we arrange these pretrials that we will try to be here in Lexington.
Okay.
Anything else, Mr. Waters?
I believe that's the
Defense?
Your Honor, that's all we have, but if we could talk about that schedule for the next pretrial.
Oh, I'm getting ready for it right now. Let me tell you what
Right,
I have. I've gone through
Right.
my calendar. And so it's hard to get lawyers together, especially when I have this many lawyers. So let me throw some dates out to you. August the 13th and the 14th. July 29th, the 30th, or the 31st.
Your Honor, so in chronological order, the first would be
July 29th,
I'm scheduled to be out of state from the 29th through the 31st.
The 4th.
okay? Then let me move on to August 13th and 14th.
Your Honor, we have a mediation on the 13th. The 14th is available. Yes, sir.
14th works for the state, John.
August the 14th,
Should,
it
Mary.
is. That will be our next pretrial. Now, with that said, I'd like to have all motions by August the 7th, if I could. I like to read my motions. I like to be prepared. So if I could have your
Love her.
motions,
I know.
I understand that some of them are late. You might think of something at the last minute, that's fine, but please don't file something at 10 o'clock at night and expect me to rule on it in the morning. Okay?
I apologize for those coming in late.
No, you're fine.
The office just to make sure we had something out there.
Mr. Waters, you're fine. I was not planning on ruling on those motions. Now, had I been, I might say something different, but please don't do that to me, okay?
Don't do it.
Now, let's talk about a trial date. The only other information I would like to know is how long this DNA is going to take. I would like to know that, but I'm going to tell y'all, I'm thinking April the 5th. And this being, I'm trying to get through Easter, and I know how hard it is to pick a jury when you've got spring break. That's usually right before Easter.
Nice.
It is the March. Is it the 28th? I think it's just the week. It's March 28th. So I'm thinking April 5th. I know that we'll have a new attorney general coming in. Mr. Harpootlian has already told me it's going to take 6 months to get experts prepared and ready to go. That would give the new attorney general time to look at his case in case he's going to be here and join us. And let me tell you this, tell both of y'all, I think y'all know me pretty well.
Okay.
When I set a trial date, I don't do continuances. I don't do it. It better be a really good reason. So How does April the 5th sound, Mr. Waters?
Yes, ma'am, so we'll be ready.
Mr. Harpootlian?
We'll be ready with some contingencies if the DNA takes longer, for instance, or,
I will have that information by next pretrial. If I need to extend it out a couple of weeks, I will, if that's the case. Please do not think that this case is going to be tried a year later, because it's not.
Oh,
We're
shit.
going forward.
more than happy with that. Mr. Murdaugh is more than happy with that. I just, again, everything.
She's
Like,
no,
because the science
we know.
in all these areas is much better than it was 5 years ago.
I understand.
8 months should be
Technology
fine,
changes
sir.
overnight. Overnight, I understand. Mr. Griffin, anything you'd like to add?
Yes, Your Honor. The Supreme Court reversed this case on misconduct by clerk of court. But the Supreme Court also addressed financial crimes evidence. And depending on how much of that or any of that comes in, will determine the length of the trial in many respects. Judge Newman last time would not rule pretrial on that issue. And it is going to be an issue that we're going to have to brief and argue with Your Honor as to, we don't think any of the financial crime evidence should come in at trial. And so I'm just flagging that it would be helpful to us, I believe, and to know if we're going to have to defend against that during the trial, or are they going to be able to put it up? And so I'm just asking.
Oh, they're going
maybe
to bring
some
it up.
earlier date where we can have, Your Honor.
So literally their whole
We
motive.
will. We will. I'm just going to tell you, I like to address all pretrial matters beforehand, because when I say April the 5th, we're picking a jury and going forward. All those issues should be decided by then.
Your Honor, that's my practice as well. We filed extensive pretrial motions prior to the prior trial, laying all our cards on the table. It's exactly why we thought that was admissible. But
Thank you. I appreciate it. Anything further before we adjourn, Mr. Waters? And Mr. Harpootlian?
Nothing for the defense.
All right, perfect. Have a good evening.
I love that Alex shook his head no. She wasn't talking to you, sir. You're not an attorney anymore.
Well, isn't she delightful? I agree. I like her.
I was going to say, I think she's going to do well, and I think she's going to tell them to get to the point.
I do too. And it really is needed with both sides. I mean, they will go, as you saw, in case you didn't watch the first trial, as soon as both sides are up, and they should, right, to a certain degree, but they just go on their tangents about, I mean, they just did it again with the DNA. Well, the science, she literally was just like, you have until next pretrial to let me know how long that's going to take, and then I'll change it. But basically, if you don't, we're sticking with this date and 2F and bad. Like, he didn't need to say anything else.
Right.
But they can't help themselves on both sides. Waters is just as bad at it. So she does seem no nonsense, which I very much do appreciate. And it shouldn't really take that much more for this case since it's a retrial. There's not a lot of new discovery, none, according to the prosecution. Though I don't know about that. You never know with discovery. There's stuff comes in. I mean, stuff was coming in the middle of trial
Right.
last time. So I don't know about that. I don't know about that at all. If you can go, I can't spend the daylight with you guys. That's true. Well,
That's
maybe
true.
though. It would be quite an interesting experience to go and check it out, though. But yeah, I do think they're going to do pre-trials all here in Lexington. I'm going to go with they'll probably do the trial here as well. They might as well.
I was going to say, she's already got the security. The staff's well organized, like she said, and it's her home place.
Yeah. That, and again, the reason that there's a retrial in the first place because of misconduct by a court employee. I don't know what else they could possibly argue from the state to not move it besides, well, it's supposed to be like people there, but they move trials all the time with juries from that new place all of the time. And I think it would be foolish to not move
Agreed.
it. So, but love the judge.
Mhm.
Interested to read some of these court documents with their arguments. The DNA on Maggie's hands or fingernails.
Under her
Interesting.
nails. That's kind of interesting.
That is interesting because that's a really particular, interesting place to have
Mhm.
a bunch of different kinds. But then again, depends how much you wash your hands. I'm going to be honest. It depends how much you wash your hands. It depends how long your fingernails are.
I'm going to
And,
say, being a good Southern woman, she washes her hands plenty.
I'm just putting in factors
Yeah.
of where a lot of this could have come from. So it does look like they're going to be, the defense plans on focusing on this genetic genealogy to figure out who these other male contributors were. And they're going to be focusing on the infotainment, the OnStar infotainment system, it sounds like. Probably the cell phones too, but they didn't say much about this.
I think I'm not going to say that.
Oh.
I was just thinking, wouldn't it be, can you imagine if the trial went crazy because they do the DNA under her fingers and it comes back? Maybe she's having a little fling on the side. And that's where it came from.
With that many different male contributors, I don't know about that.
Well, I
No,
thought they said
so
just one other male.
no, there was like 5 different ones,
Oh, there
but
was 5
one
different ones.
was, there are 5 DNA profiles different that were, Alec was ruled out, and then there was one that was specifically a male, I think is what they
Okay.
said.
Okay, that's what I thought they
About,
said. So I thought one was just a male. So
yeah. Though I will say, it could be chicken DNA. Their old housekeeper,
Mhm.
Bianca, like she wrote a book, and hers was very interesting. I mean, listen, the housekeepers know all sorts of secrets.
They know it all.
But she said that actually their marriage worked for them. She did talk what seemed to be Alec was seemed like he was going through a depressive episode, could have been an addiction in a couple of months before, but it was certainly a very interesting read, Bianca, right? Is that her name? I think that was her name. Interesting book she put about that. So yeah, I mean, there's always rumors. Everybody's having affairs. I'll just say that's not what the housekeeper implied. She implied that they actually had, even though it's not your traditional type of
It worked for them and they were.
step, yeah. So, but that doesn't mean anything either, at all. Who knows what people were doing in their lives? But it is DNA under the fingernails is an interesting one. Again,
Mhm.
why was Maggie's phone taken and not
Yeah, did
Paul's?
they do DNA on the phone to see whose DNA was on it for it to be thrown or put out?
Who knows? Sled did a fucking awful job with everything. So I don't even remember what all they messed up or didn't do
Yeah.
during their invest. I mean, it was so bad, you guys. So embarrassingly bad. Yeah, she was. I thought she was at the beach. She came in that day from the beach
Yeah.
house. Wasn't she in town for something else anyway? It wasn't just to go back home. Oh, it was something to do with the mother-in-law or the father-in-law was unwell. I think it
I
was.
don't remember.
She came in for another reason as well. I can't remember. But that's okay. We'll get to relearn it all again. See what both sides have to offer or do different this time around. Waters made it sound like he doesn't plan on changing very much up. And
I
I don't
was
know if
gonna
he heard
say,
the Supreme
he
Court,
yeah.
because I would be changing some of the stuff up for sure. Because they were problems that some of us have with the trial and their presentation of the case. If they go in there being like, this is a slam dunk, I think that's very, very arrogant, especially if they get this in this venue with this jury where people, they know Murdaugh, but they don't know Murdaugh.
Right.
You know, the last, back where it all happened, like everybody knew this family. They were a legacy there.
Mhm.
So I don't know. I think they definitely need to change some things. Murdaugh's father was ill. Okay, I couldn't remember
Yeah.
if he was at the time of this too, or if it was shortly after. Because doesn't his
Yeah.
dad like pass away shortly
It does,
after
somewhere
this?
right around there. Yeah.
Yeah. Yeah. And Alec asked her to come back. Okay, yeah. Like I said, I don't remember all the. Oh, the mother was ill? Okay. I don't know. It was one of those. Don't worry. We'll deep dive it all
Well,
very, very soon. Um, but that's all there is for today. Their next pre-trial is next Friday. Yes. Yes, we will be streaming the trial, Kelly.
I love that.
Yes.
Asking for a friend.
Yes, this is why we're doing our trying to catch up with it so that way we don't get too behind because as the judge said, April 5th, it is on unless at this next one they have a better time frame for the DNA
We'll find out.
evidence, which does take a long time, 6 to 9 months at least. So there is
Yeah.
a chance, but it wouldn't be pushed off by much, I doubt. But no, we'll definitely do that. I also heard that the Sarah Grace Patrick trial got postponed again. So I'm not saying that they were thinking about my schedule or anything, but I think they were when I said, I'm sorry, I can't cover it because it's school starting. So, but apparently that was supposed to start today and has now been delayed with no trial date set. So,
And
who
she's
knows?
not going to do a continuance. She said it's happening on the 5th, or it better be something big.
Oh, yeah. Yeah. I very much appreciate her already. So, very excited about her. So far, she seemed very fair in hearing both sides out. And I think
Okay.
Judge Newman was fair on most things as well.
Thank you, Amos. That's what I thought because his dad passed away like a couple of days after the murder.
Okay. And the mother was taken care of at
Yeah.
home because they were both
Because he
very.
went to see her that
Oh.
night, his mom, and he sat and talked with her.
Oh, yeah. That's right. And then there's the whole tarp and oh my God. Oh, never mind. I'm having PTSD from all the nonsense of the last one. It's going to be a long one. How long was the last trial? 6 to 8
I
weeks.
think they
It
went
was.
6 to 8 weeks.
Yeah. I think it ended up being around 6 weeks. It could probably be 4 weeks if they condense some of this financial crimes.
Mhm.
Now, will they? I don't know because the Waters
But
is dead set on it for the motive.
I know, but part of the things that granted, they overturned it partly because they gave too much of it. But now that he's been convicted of it,
Yeah. Oh, they gave everything away the first time.
yeah.
All of it. Which I did have a problem with that because it's like, well,
Yeah.
he's not even found guilty of this. or
Yeah,
pled
now he
guilty,
is,
but
though. Now he's guilty.
yeah. But do they need to go and spend 2 weeks on it?
I don't think so
No,
because
they didn't
he's
need to in
already
the first
admitted.
place. Oh God, it was awful. Oh my gosh, it was just financial stuff that would never end. Never end. It was obnoxious, but that's the thing. Like I said, both sides are talkers. Both sides love hearing the sound of their own voices, as you can see. 6 weeks. All right, thank you. 6 weeks, January 23rd to March 2nd, which is when a bunch of us met each other in the YouTube chats, was the Murdaugh trial, or shortly after that. So it's like full circle. Like I said, I have my own opinions about the first trial. I am going into the second one with an open mind as well, but I am going to need the state to step things up a notch for them to
Mhm.
convince me a second time around because they didn't the first time. But that's just me. So I wonder if they're going to point the pew pew and call that or
Yeah.
not.
I hope not, because you should never do that.
No, and it was so, and that's the thing too. I mean, this is also why I enjoyed, like I said, the lawyers are very dramatic. They are performers, both Waters, Poot, performers through and through. But yeah, it wasn't really necessary. Well, if he did not do it and he knew who did, that would still make him not guilty of murder. You see,
Right.
you see. So there's that.
Yeah.
Yeah, so it was such a mess, and they weren't even like using gloves for most. Do you remember what a shit show it
Oh
was?
yeah, they were just handling things.
Yeah. Oh God, it was insane. I can't wait for round 2. You're gonna get lots of llama probably being like, "My God," to both sides. But I will say this, they are interesting and good lawyers to watch. I've seen worse.
I find
Oh
them
my God.
entertaining. I like the dramatics in court.
It's certainly something you don't see very often anymore. Oh yeah, it's a cone. Or there was the, armpit coroner to determine the body temperature. That was good enough just to test their armpits with his hand.
Yeah.
It was something. It was something. So you met us during Lori Val. Oh yeah, because that would have been a couple of months right after, right? Because she went first, then Chad, and then she went again. So yeah, because that happened in like April or May, right after Murdaugh. That's right. Well, I know I'm certainly interested in following this further. Gonna get some of those court docs over the next week.
I hope this trial's better, and the state does need to do a better job of proving beyond a reasonable doubt for me.
And who knows? They may. Who knows what's going to happen? I have no idea. But they need to be careful not going in all arrogant about the case. That's going to be your biggest downfall, because there's another thing that jurors typically don't like, and that is arrogance of a side. Like they can sense it and they can feel it. I've seen numerous juror interviews after the fact on various cases. I mean, hell, Casey Anthony's jury straight up said the state was too cocky and arrogant about it, and I didn't like them. It was one of their many reasons, besides the fact that they did, in fact, overcharge her based on what they had. But anyway, she they notice these things, so they're gonna have to, be cool about it. So we'll see. We'll see. In my opinion, I think that his drug suppliers did it and he saw it happen. Well, then that means you found him not guilty of murder, though. Like and that's what I'm saying, is that the state to me did not do a very good job making it so everyone was like, yeah, that guy totally did what we're accusing him of doing. They didn't do that for me. Did they convince me he's a shitbag? Yeah, absolutely. This guy's a shitbag. I don't like him. But I don't know. Oh, Rosalind Duke says hello. Well, hello back to Roz, and hello, Tina. Welcome. Oh, right, that's nice. Why does that not pop up on our end that we're having one? Oh, they did love Jose Baez. Jose Baez, very good attorney, also dramatic.
But remember, the judge, you kind of got the feeling when we talked to Blevins, he thought the state was too cocky.
That's true.
He thought the
Teri,
state himself was too cocky.
on our channel, you can find Teri and JT's interview with Judge Blevins, the judge from the Casey Anthony trial, was on about 2 years ago, because he had a book out about his time as a judge. Fascinating interview to watch. He was a very cool guy. I wish I wasn't on this side of the camera yet.
Process a little bit slower.
But I mean, he had a lot to say about how he felt the state's case wasn't great either, and how they presented it, and their arrogance about things, and about how his hands were tied in certain areas. Anyways, very, very fascinating.
Bias on OnlyFans.
What? Jose, that didn't even exist then, did it? No.
I'm like,
I don't think so. I don't know.
I don't have an OnlyFans, and I don't want to go down that rabbit hole.
But I do know, speaking of OnlyFans, Courtney Clancy, or Clinny, sorry, that's Lindsay Clancy. Courtney Clinny, she's taken a plea deal. So next Monday, she is being sentenced, and I think we're going to watch it on Couch Court, maybe. They haven't said yet what her plea deal was, but sentencing, victim impact will be next Monday. I mean, that's another case that has been going on for years. that we keep planning on covering and talking, but then it gets pushed and pushed and pushed. So that news broke over the weekend. I was actually really surprised about her taking that plea deal, but I mean, I don't know if it would have helped either way. Probably offered a pretty good deal. At least she didn't
Probably.
Sarah Boone it. So there's that. And apparently the plea deal was very supported by the family, according to reporters. So, if they were fine with, and honestly, I can see that because I'm sure they wouldn't have wanted, the victim to be dragged through the mud because there was a lot of reported abuse on both sides or talked about, so they seem to be in support of it too. So not Baez, the prosecutor. Oh, I did not know that, Tina. I did not know that at all.
Okay.
Interesting. Well, I think that's all we got today for you, friends.
I think
Um,
so.
Next Monday, we'll be back with Murdaugh. We'll probably be talking about some court documents that are either going to be talked about for pretrial, or we might get into the Becky Hill civil lawsuit, one or the other, unless something else pops off. But we'll definitely be talking about next week. Will be Murdaugh Monday and
Murdaugh.
Friday.
And Friday, that's correct.
So, because I don't think, unlike other trials, everything they go to pretrial, it's going to take forever. Okay.
Yeah, she said there's going to be multiple pre-trials.
Well, there's going to need to be if they're not going
Yeah.
to trial till April. But the way these people all talk, like they're going to be long ones. So just reserve your afternoon with us, because I think we're going to wait to watch it in the afternoon that Friday. Plus, then we can speed through the little breaks or whatever. I don't know. We'll know more. But we'll be doing that. He was charged with misconduct. Oh, interesting. Interesting. So, that's all I got. Tomorrow I'll be live at 10 a.m. Eastern, right? Yeah, for something. Oh, this is my calendar says March. No wonder. I'm like, why doesn't it say very much?
Aren't you O'Keefe?
Yes. Tomorrow over on Couch Court with Llama, we'll continue with our catch up on the O'Keefe v. Karen Reed wrongful death civil lawsuit. So if you are not caught up with that, come watch me over there. I have read all the documents for you. We're going to summarize them. We're going to read some of them. We're going to watch the hearings. I have a slideshow for you and everything. So you can join me tomorrow for that. And what about for you, Teri?
Tonight, I have Dearest Mother's Darkest Secrets with covering Diane Downs, and then back on Wednesday for Midday Missing.
Yeah. Oh, and then Wednesday in the Courtyard Discord server, we are watching the new Idaho Murders College Nightmare three-part documentary that came out. We'll be watching that on Discord, so you can watch along with us. And then Teri and I will come live on YouTube and talk about it. So if you haven't joined our Discord, so you can watch that with us, I've been good and haven't watched it at all. I basically can't watch television anymore. Just kidding.
You got plenty of Housewives and Dragons to watch.
Dragons is over next week.
I know.
Anyway. Well, that's all we got for you today then, friends. Catch her tonight.
Yes.
9 p.m. Eastern. Catch me tomorrow morning. I think Buff's on with me tomorrow morning. 10 a.m. over on Couch Court with Llama. Please go, subscribe not only here on True Crime and Wine Time, but on at Couch Court with Llama as well. And thank you. We're happy to have you, Tina. Hope to see you again. And other than that, I guess, as I always say, go forth and be amazing. What do you have to say, Teri?
Be safe, stay away, and remember it's free to be kind.
That's right. All right. Bye, friends.
Bye, guys.